In today's digital world, data is more valuable than oil. Every time a client signs a contract online, every time a company transfers records across borders, every time an employee logs into a system, data is being created, stored, and shared. But what happens when things go wrong? A company suffers a data breach, exposing thousands of customer records. A government agency fails to secure cross border transfers. An employee mishandles sensitive personal data. In each case, lawyers must step in, not only to manage the crisis, but also to advise on compliance, risk, and liability. This is where cybersecurity law and data protection law meet. They don't just protect systems, they protect rights, reputations, and businesses. In this lesson, we will see how advanced legal English helps lawyers talk about these modern risks clearly, precisely, and professionally. If you want to go beyond the theory to practice legal English in live sessions, work with real case studies, and get direct feedback on your professional communication, join our legal English community. Inside, you'll find courses, live sessions, and a global network of lawyers and professionals who are building their careers in English. The link is in the description, and join us and start mastering legal English. By the end of today's lesson, you'll be able to talk about technology, data protection, and cybersecurity law in advanced English. We'll start with vocabulary, key terms, GDPR, data breach, encryption, and cross border transfer that define this fast changing area of law. Then we'll explore grammar structures that lawyers use to describe obligations and risks, modal verbs to show what is required or forbidden, and conditional forms to explain what happens when breaches occur. We'll also look at professional legal phrases, expressions like data subject rights, lawful basis for processing, breach notification, and regulatory compliance. These phrases are what lawyers and regulators actually use when discussing cases. Finally, we will apply everything in a practical scenario. You'll see how these tools come together when advising on real world issues in technology, data protection, and cybersecurity. Let's start with a story. A mid sized international law firm discovers that its email server has been hacked. Suddenly, sensitive documents, client contracts, witness statements, and even confidential arbitration strategies may have been exposed. The partners gather in an emergency meeting. IT team explains the breach. A regulator calls, reminding the firm that under data protection law, they may be required to notify both the authorities and the affected clients within strict deadlines. One partner asks, who is responsible for the breach? Us or the IT vendor? Another demands, how do we explain this to our clients without losing trust? This is more than a technical problem. It's a legal, reputational, and regulatory crisis, and it raises practical questions. What obligations does the firm have under cybersecurity compliance rules? How quickly must it send a breach notification? How should the lawyers communicate in clear, precise English under pressure? This story is not science fiction. It happens every week around the world. It's why lawyers today must be able to discuss data protection and cybersecurity law confidently in English. One of the most important laws in the world today for data protection is the GDPR, or General Data Protection Regulation. Passed in the European Union in 2018, the GDPR set a global standard. It requires companies to be transparent about how they collect, store, and use personal data. It also gives individuals powerful rights over their own information. Imagine a multinational corporation based in London that collects customer data from France, Germany, and Spain. Even if the company also operates in the US or Asia, it must comply with GDPR whenever it processes data of EU citizens. Failure to comply can be extremely costly. For example, regulators can impose fines of up to 20 million euros or 4% of annual global turnover, whichever is higher. You'll hear phrases like GDPR compliance, GDPR enforcement, GDPR fines and penalties. For lawyers, GDPR is not just European law, it's international law and practice. It affects contracts, litigation, and risk management across borders. And in English, being able to talk about GDPR fluently is a key professional skill. In cybersecurity law, one of the most common and serious problems is a data breach. A data breach happens when unauthorized individuals, hackers, employees, or even careless contractors gain access to personal or confidential information. That might mean stolen client contracts, leaked medical records, or exposed financial details. Picture this: a healthcare company loses a laptop containing unencrypted patient files. This is a data breach. Or a bank discovers hackers stole login credentials to thousands of customer accounts. Again, a data breach. Why does this matter for lawyers? Because data breaches trigger legal obligations. Under GDPR, companies must report breaches within 72 hours. They may also have to notify every affected customer. Failure to act quickly can mean fines, lawsuits, and reputational damage. You'll hear phrases such as report a data breach, suffer a data breach, breach notification obligations. For advanced legal English, you need more than just the term itself. You must be able to describe the legal consequences and the duties that follow. One of the strongest defenses against cyber risk is encryption. Encryption means turning data into a coded format that can only be read with the correct digital key. Even if hackers steal the files, they cannot understand the information without the key. Imagine a law firm sending confidential arbitration documents by email. If the documents are encrypted, even if the email system is hacked, the data is unreadable. Without encryption, the information could be exposed and cause irreparable harm to clients. In many legal systems, encryption is not just recommended, it is a compliance requirement. Regulators may reduce penalties if a breach occurs, but the stolen data was encrypted. You'll hear common phrases such as strong encryption, end-to-end encryption, encryption standards. For lawyers, this term is practical. When advising clients, you may need to ask, was the data encrypted? The answer can make the difference between a manageable compliance issue and a catastrophic liability. In today's global economy, businesses constantly move data across borders. When this involves personal or sensitive information, the law calls it a cross-border data transfer. For example, a U.S. tech company stores European customer data on servers in California, or a law firm in London sends client files to its office in Singapore for review. Each of these is a cross-border transfer, and each may be restricted under laws like the GDPR. Why is this such a big issue? Because different countries have different standards of data protection. The GDPR only allows personal data to move outside the EU if the receiving country ensures an adequate level of protection. That's why agreements like the EU-US Data Privacy Framework or standard contractual clauses exist. You'll hear key phrases such as restrict cross-border data transfers, authorize cross-border data transfer, adequacy decision for data transfers. For lawyers, this concept is central. Advising clients on international business means explaining when and how data can legally move across borders. Mismanaging a cross-border transfer can trigger regulatory investigations and multi-million-dollar fines. When a data breach happens, the law doesn't just expect silence, it demands disclosure. This is known as a breach notification. Imagine a financial services company discovers hackers access customer bank details. Under GDPR, the company must notify regulators within 72 hours. In some jurisdictions, they must also inform every affected customer, explaining what data was exposed and what steps are being taken. Failure to issue timely breach notifications can lead to severe fines and reputational damage. Regulators argue that transparency protects individuals and forces companies to act responsibly. For lawyers, this term is critical. You may need to draft breach notifications, advise on deadlines, or challenge whether disclosure is legally required. You'll hear key phrases such as issue a breach notification, breach notification obligation, breach notification deadline. This phrase shows how law and communication intersect. It's not enough to secure systems. Lawyers must also ensure that when security fails, the legal response is precise, fast, and compliant. At the heart of modern data protection law are data subject rights. A data subject is simply the individual whose personal information is being processed. Laws like the GDPR give those individuals powerful rights to control their data. For example, a customer can request to see what information a company holds. This is the right of access. They can demand corrections to errors or even ask for their data to be erased, often called the right to be forgotten. They can also request data portability, having their information transferred to another provider. Imagine a social media company. A user in France asks to delete their account and all their personal data. If the company refuses or delays, it may face heavy penalties for violating data subject rights. You'll hear key phrases such as exercise data subject rights, data subject rights request, or also violation of data subject rights. For lawyers, this concept is central. Advising clients often means balancing corporate interest against these individual rights. In English, being able to talk about data subject rights clearly shows a deep understanding of data protection law. In data protection law, no company can simply collect or use personal data without justification. They must identify a lawful basis for processing. Under the GDPR, there are 6 possible lawful bases: consent, the individual agrees; contract, processing is necessary to fulfill an agreement; legal obligation, required by law; vital interest, to protect life or safety; public interest, for official functions; and legitimate interest, a balanced business reason. Imagine an online retailer. It collects customer addresses to deliver product. That's a contract basis. It stores tax records. That's a legal obligation. But if it wants to send marketing emails, it usually needs explicit consent. Why is this important for lawyers? Because the lawful basis determines whether data processing is valid. If a company chooses the wrong basis, regulators can impose massive fines. You'll hear key collocations such as establish a lawful basis for processing, challenge the lawful basis, rely on consent as a lawful basis. For advanced legal English, mastering this phrase shows you can discuss not just technology, but the legal logic behind every act of data processing. In data protection and cybersecurity law, language of obligation and prohibition is constant. The clearest way to express it in English is with modal verbs. For example, under GDPR, companies must report a data breach within 72 hours. The word must signals a strict legal duty. Personal data may not be transferred outside the EU without safeguards. Here, may not makes the prohibition formal and precise. Firms have to provide individuals with access to their data upon request. This structure works like must, but sounds slightly less formal. Organizations must not share sensitive data without consent, a strong absolute prohibition. Imagine advising a client after a cyber attack. You need to explain, you must notify the regulator. You may not delay beyond 72 hours. You must not inform the press before informing your clients. Using the right modal verb is more than grammar. It reflects legal accuracy. And for advanced legal English, these distinctions matter because they mirror the way laws are drafted and enforced. In cybersecurity law, lawyers often need to explain consequences and hypotheticals. Conditionals are the perfect tool. Let's look at three types. Real conditionals: if plus present, will plus base verb. If a company encrypts its data, it will reduce liability in case of a breach. This shows a clear cause and effect relationship. Unreal conditionals: if plus past, would plus base verb. If the firm had better training, it would prevent most breaches. This expresses a hypothetical, something not true at the moment. Past conditionals: if plus past perfect, would have plus past participle. If the firm had reported on time, it would have avoided the fine. Here, we look back and show what should have happened but didn't. We also see formal inversions. Were the safeguards stronger, this breach might not have occurred. Imagine explaining to a board of directors, if the company had encrypted files, this problem would not exist today. Had you acted sooner, you could have avoided the regulator's penalty. Conditionals allow lawyers to show risk, explain mistakes, and propose solutions. They turn complex technical issues into clear legal reasoning, exactly what clients and regulators expect. In cybersecurity law, the passive voice is used constantly. Why? Because the focus is often on the data, the process, or the regulation, not on who performed the action. For example, personal data is processed according to GDPR rules. The subject is the data, not the company. The breach was reported within 72 hours. The emphasis is on compliance, not who pressed send. Penalties will be imposed if compliance fails. Here, the actor, the regulator, doesn't need to be named. The focus is on the consequence. Imagine a compliance report. Instead of writing, our IT manager encrypted the files, a lawyer writes, the files were encrypted before transfer. The passive form sounds more formal, more objective, and more suitable for legal documents. Key uses in cybersecurity law are regulations. Data is protected by encryption. Reports. The breach was detected by the monitoring system. And penalties. A fine was imposed by the authority. Mastering the passive voice ensures your language matches the professional style of legal writing, compliance reports, and regulatory frameworks. In cybersecurity and data law, one phrase you will hear constantly is regulatory compliance. This refers to the duty of companies to follow the laws and standards set by governments or supervisory authorities. For example, banks must follow financial data rules. Hospitals must comply with health data protection laws. Technology firms must meet GDPR or local data protection regulations. Imagine a multinational company under investigation after a breach. Regulators ask, was your regulatory compliance program adequate? The company's answer will decide whether it faces a warning, a fine, or even a suspension of its license. Lawyers play a central role here. They design compliance frameworks, review contracts, and train staff to ensure that the company can prove it followed the rules. Key phrases include regulatory compliance programs, failures of regulatory compliance, regulatory compliance audits. This phrase is essential. It conveys not just following the law, but building systems to prove compliance under scrutiny. In cybersecurity law, many disputes come down to whether an organization has breached its duty of care. Duty of care means that companies must act reasonably to protect the data entrusted to them. If they fail, for example, by not updating software, ignoring known risks, or failing to train staff, the law may find a breach of duty of care. Imagine an online retailer that stores thousands of customer credit cards without encryption. Hackers break in and steal the data. A regulator or court might conclude the company was in breach of its duty of care. Reasonable steps to protect the data were not taken. This phrase connects cybersecurity obligations with general principles of negligence. It is often used in litigation, regulatory findings, and compliance assessments. You will hear key phrases such as breach of statutory duty of care, negligent breach of duty of care, breach of duty of care in data security. Using these phrases demonstrate that you can frame cybersecurity issues not just in technical terms, but in the language of legal responsibility and liability. One of the sharpest legal duties in data protection law is the breach notification obligation. This means that if an organization suffers a data breach, it must inform regulators, and often the affected individuals, within a set time frame. Under GDPR, the deadline, as we discussed before, is 72 hours. You can imagine a financial services firm discovers that hackers access client investment accounts. Even before the full investigation is finished, the firm has a legal obligation: notify the regulator. If customer details are at risk, it must also notify the clients themselves. Failure to meet this obligation can result in heavy fines and reputational damage. Regulators treat silence as negligence. Lawyers often draft breach notifications, review whether disclosure is mandatory, and ensure the content is legally compliant. You'll hear key phrases such as fulfill breach notification obligations, breach notification deadlines, failure to meet breach notification obligation. This phrase is technical, formal, and central to data protection practice. It's the difference between proactive legal compliance and costly regulatory penalties. Let's put everything together in a real-world story. A multinational law firm wakes up to a crisis. Its servers are frozen by ransomware. All client files are locked, and hackers demand a payment in cryptocurrency to restore access. The IT team scrambles to contain the attack. Meanwhile, the legal team must act under intense pressure. Within hours, they face three urgent questions: regulatory compliance, the firm must notify data protection regulators. Lawyers prepare reports using passive forms. The breach was detected. The systems were compromised. To keep the tone professional and objective. Breach notification obligation. Clients whose files may have been accessed must be informed. A partner drafts: if your data was affected, you will be contacted immediately. The conditional phrasing reflects both legal caution and compliance with notification laws. Duty of care. Regulators ask whether the firm took reasonable steps to prevent the attack. Lawyers must prove encryption was in place and that a compliance program existed. If not, the firm risks findings of a breach of duty of care. The partners debate payment. One argues, if we pay, the hackers might release the data anyway. Another responds, had we invested in stronger safeguards, we wouldn't face this choice. This is where law, language, and strategy converge. Through advanced vocabulary like GDPR, breach notification, lawful basis, and precise grammar like conditionals and passives, the lawyers explain obligations, defend the firm, and guide the response. The story ends not with a technical solution, but with a legal one. Clear communication, professional phrasing, and strategic compliance, the tools that allow lawyers to lead during crisis. Let's recap what we achieved in today's advanced lesson. First, you built your vocabulary for data protection and cybersecurity. Terms like GDPR, encryption, breach notification, and lawful basis for processing that every international lawyer needs to use with confidence. Second, we practice grammar structures that give you precision in professional communication. You saw how modal verbs show obligations and prohibitions, how conditionals explain consequences, and how the passive voice keeps reports formal and objective. Third, you learned 4 legal phrases that sharpen your courtroom and compliance language: regulatory compliance, breach of duty of care, breach notification obligation, and lawful basis for processing. These are the exact terms regulators, judges, and lawyers use in data cases. Finally, we brought it all together with a practical story. In a ransomware attack, we saw how legal English helps explain obligations, defend against liability, and guide clients through crisis situations. This is the goal of advanced legal English: not just speaking correctly, but also speaking like a professional, precise, persuasive, and strategic. If you'd like to practice further, join our legal English community where lawyers from around the world practice together for the realities of global legal practice.